iPhone.
That is correct.
And did she confirm with you on the phone prior to seeking and obtaining the second search warrant on the defendant's phone that she had had some inappropriate relationship of a sexual nature with the defendant online?
Yes.
By June the 24th and June the 27th, when this, we'll call those the dates of the second battery search warrants were issued, this information about the defendant's relationships with these two other girls, was that contrary to what the defendant had told you on the 18th?
That is correct.
And is that part of the reason why you asked Detective Murphy to seek additional warrants expanding the scope of the search of the prior items that had been recovered?
That is correct.
Do you recall when it was that you actually received the CD from High Tech involving the actual phone?
Yeah, the phone, the disc phone, the iPhone was received on June the 25th.
Now, on that date, did you do any actual additional search of it prior to getting the additional search warrant?
It is possible that I opened up that disc. I would put it in the computer and make sure there was information on that disc. I did not do any active or intense drawn out searches.
Now, at that point, you did have an active search warrant that was in place that would authorize you to look onto the device.
Yes, sir.
On the 27th, is that the date that you had Detective Murphy obtain the additional search warrant to expand the scope of the permissible search of the iPhone?
Yeah, the original batch was done on the 24th, as we've gone through with Mr. Lumpkin earlier. The phone was not in that original batch. It was added on the second batch that Detective Murphy did on the 27th.
Just so we're clear for our record, State's Exhibit number 4, search warrant ending 0599, was the original search warrant for the phone, correct?
It appears so.
Okay. And then the 27th search warrant, June 27th, for that phone. That's State's Exhibit 310660. Is that correct?
Correct.
Okay. This second search warrant, on the second page, if you'll read this line starting, Harris also claimed.
Harris also claimed that he is happily married. Nonetheless, evidence of inappropriate sexual communications with other women had been obtained.
You're talking with Detective Murphy throughout the course of the investigation, is that correct?
That is correct.
And as you're getting information that you believe to be pertinent, are you sharing with him, specifically when it comes to you requesting that he obtain additional search warrants?
Yes, sir.
the basis that you just talked about for that particular search warrant 0660, is that what you just testified about for before Judge Staley involving these two women?
That is correct.
After the second search warrant was obtained, can you describe for the court how it is that the hard drive for these electronic devices came into your possession such that you could actually begin the actual search of them?
We would receive disks from the high-tech unit.
And specifically for the phone in this particular case, you had already received at least one disk, is that correct?
That is correct.
Did you at some point receive a more complete copy of that disk, or is that the one that you worked off of?
That's the one we initially worked off of.
And after the second search warrant, well, let's say prior to the second search warrant, other than looking at the call detail from that particular day that you had talked about, did you conduct any more extensive search of that phone for evidence of any appropriate contacts with other women other than from that day?
No.
When is it that you went back into the phone to expand the scope of the search?
It was after the second search warrant. When you receive a disk from high-tech, you have to save it to your hard drive. If you don't save it to your hard drive, it's very slow, it's cumbersome to look at. You can look at it, but it's not the way we do it. What we do is we take the information from the disk and it's copied to your hard drive. I have in my notes, and on the hard drive, it was on my personal computer at work. It was copied to the hard drive on June the 30th. So we received the disk on 25th and copied it to the hard drive on the 30th.
And when is it that you actually started going through the phone in terms of looking for things that were authorized from the second search warrant?
It would have been the 30th or after.
I want to talk about the scope of the searches of the other electronic devices that were initially seized on the 18th and 19th. When you initially received permission to seize those items, did you immediately, once those search warrants were obtained, begin searching through the devices?
No.
Did you conduct any searches of those devices prior to obtaining the second battery of search warrants on June the 24th?
No.
No searches were conducted on the Lenovo, other than the extraction process we've heard testimony about. The
Correct.
actual searching of the devices, that didn't occur before the 24th.
That's correct. And high-tech did their job. It was after, or would have been after the 27th when we started getting disks.
Can you explain to the court why it is that you asked Detective Murphy to come back in and get State's Exhibits 6 through 12 from the 24th, these certified search warrants? Why it is that you asked him to obtain additional search warrants? What was the purpose of that?
Two things. Number one, we had also readjusted the arrest warrant. We had changed it to Crowley II, and the reason we changed it was, Crowley II. The reason we did that was because we received the autopsy report. It was hyperthermia as opposed to what we thought was a lack of water or sustenance in the vehicle that day. It was actually due to heat. It was a heat death. It was what killed the child or killed Cooper Harris that day. Also, the information about, now we had the two ladies that we had actually talked to, giving us information concerning the inappropriate relationships that he was having.
Now, let's be clear for our record here. At this point, y'all have the devices, but other than the beginning of the extraction, the searches had not really been conducted of them, other than what we've already talked about for the iPhone. Is that correct?
That is correct.
Did you, after obtaining the search warrants from the 24th, then begin at some point looking onto the devices for the authorized permitted material, including evidence of problems with the defendant's relationship?
That is correct.
Before we leave this topic and talk a little bit about scope, I want to ask you about a particular video that the defendant had mentioned during his interview, having watched online, involving car deaths. Do you recall that?
Yes, I did.
And at the time of the interview with him, did he articulate for you which device that video could be found on, or how it is that he observed that on his iPhone versus some other device?
He did not.
Based on that, did that impact your request for search warrants for electronic devices for this defendant who admittedly works as a web designer?
It did.
Explain.
We didn't know where this video was coming from. We don't know whether this was a video that was sent to him, emailed to him, watched online, saved on a file, given on a disk. We don't know. And so due to that and due to the news report, we're not sure where the news report was also watched at, and we expanded it. Make sure that we could cover all the devices, because nowadays you can use any of the devices. You can use an iPad, work computer, home computer, phone to watch those or to look those videos up.
Had the defendant only had one laptop and one iPhone, would that have impacted the number of search warrants you asked Detective Murphy to obtain?
Yes, it would have.
And how so?
If you only have one phone, it would have been one search warrant for the phone, as opposed to he has multiple devices or access to multiple devices, multiple search warrants.
In this particular case, did you actually at some point find and observe that video involving a veterinarian in a hot car documenting what occurs inside the vehicle?
Yes, I did.
And on what specific device was that video found?
It was found on the work computer, the Lenovo T530.
Okay, let's be very clear about that. Where was that specific device taken from initially, pursuant to the initial search warrants?
It was taken from the vehicle.
His vehicle?
It was taken from his vehicle in a computer bag.
Now, we've heard some testimony just a moment ago about that computer being encrypted and belonging to Home Depot. Is that correct?
That is correct.
In addition to it being encrypted, when you were able to open up that laptop, the Home Depot laptop found in his car, did you photograph the lock screen to show that there was some sort of disclaimer about this belonging to Home Depot and being Home Depot property?
Yes, this was photographed recently.
This is State's Exhibit 43, which for the record is 2 plastic sheets, admittedly with 3 photographs stapled together. Is that correct?
That is correct.
And these are fair and accurate pictures that you took of that locked screen showing that this had an advisement that this was Home Depot property, correct?
Correct.
Tender States 4-3.
Just so we're clear, you took those pictures recently, but are you telling us that's what you saw on that computer screen back in June of last year?
No, I did not look at the computer back in June of last year.
Okay. Was it any time last year that you saw that, or just this year?
This year.
It's not relevant. It matters, actually.
Relevant to standing, there's already been a question about, a lot of question about the laptop being encrypted and being the property of Home Depot. This confirms the prior testimony that you've just heard about that issue, and I don't believe the defendant has standing. This would tend to prove that.
Well, there's no evidence that this existed last year when they were looking at it. I don't know where the warrant came from and how it got on there. They're the only ones who had possession of it. So unless there's some evidence that that was actually on the computer at the time they looked at it, it's impossible.
We can develop this.
Have you done anything to alter that computer since it was initially seized?
I have not done anything to alter that computer.
And from where did you get that? Where did the computer go once it was seized on the 18th and 19th?
The computer went from, it would have gone either to the CAPER or Crimes Against Persons evidence room. From there, it would have gone to high tech. High tech would have done their job, their work on it. And from there, it would have gone either back to the CAPER or Crimes Against Persons evidence room and down to our evidence locker downstairs.
In advance of this hearing, we were asking you, we being Mr. Boring and I, some questions about this computer. Did you actually reach out to Home Depot to ask them about their laptop computer that you had in your possession?
I did. We knew the computer was Home Depot property. I reached out asking how they knew or how they would tell their employees that it was their property, or if there was any warnings, any forms they filled out. And Mr. Parton, one of the managers there, emailed me back with a snapshot of the screen. I went and pulled this computer, and the snapshot was very similar. I went downstairs, pulled the computer out of evidence, I opened it up, turned it on, and this is the first thing that comes in, that comes up on the computer screen.
And is there a disclaimer or admonition on there that basically says, I'm paraphrasing here, that this is Home Depot property, and by logging on to that, you're agreeing to that?
Yes. And to read it real quick, the information of the system is confidential and proprietary and is available only for approved business purposes. This system and any related information is not to be used for any purpose that is unlawful or prohibited by any policy instituted by the company. And at the end, as your use of the system constitutes your agreement and acceptance of these terms.
Did Home Depot confirm for you when you talked to them that this was their property that they had purchased for work-related purpose for the defendant?
That is correct.
Okay. I want to talk a little bit about this.
I'm going to object to the state intentionally violating a rule of evidence by reading into the record something that we've got an objection to, that they're trying to suggest that this was on the computer screen at the time back in last year, so that Mr. Harris would have had to have seen it and known that this is a Home Depot property. He had no expectation of privacy. It's what I anticipate they'll argue. But if someone actually from the police department got on that computer and did some analysis of it, somebody had to have seen it if in fact it was there back then. I don't trust that it was there back then unless they've got some evidence to that. I'm going to ask the court to strike from the record. They're reading into the record what's on this document that's not properly before the court.
It's been tendered. I believe it's been admitted. It should be admitted. There's been a foundation for it. There's been no evidence that this item of evidence has been altered. You've already heard testimony from Detective Yeager taken in conjunction with this, that back when he initially wanted to review this laptop, he had to contact Home Depot in order to get the encryption code because it was their device. So this is not something new. That's certainly consistent with what this detective was able to see in advance of this hearing. So I don't think it's improperly before the court. The foundation's been laid for it. It should be admitted and be admitted for the purpose of defeating the defendant's standing, which the defense, by the way, has the burden of establishing. Is one of the areas in the law where the defense has the threshold burden of establishing standing, and if we're able to defeat that, obviously the court needs to be able to see it.
If they had the witness, and they did have him here earlier today, if in fact it was there at that time, to where the court can make that logical leap that yes, it must have been there when Mr. Harris last saw it, but that witness was here and he never said that. Yeah, he did talk about a code, but if in fact it was true, why didn't we have him? Why don't we tender it to him and have him talk about it? Why don't we have a detective now talking about some picture he just took recently? It was tendered. I've objected. The state then attempted to lay a foundation, and then they went in and actually put in all the information into the record.
Probably.
I was going to talk to you now about the scope in terms of the analysis of the different devices that you have in this particular case. To what degree was the defendant's admission to you that he had some electronics background? To what degree was that a factor in terms of how you were going to assess the search of these devices?
It was a large factor.
Can you explain to the court?
He stated he was a web developer. In fact, they are opening a company to develop web pages. We can assume that...
I object to any more assumptions from this officer or any other Cobb County Police Department officer coming before this court in testimony.
The defense has objected to the scope of the actual searches. I think this witness is perfectly capable of explaining to the court why it is he might have looked into certain areas versus other areas in terms of the scope that the defense is claiming was unlawful in their own motion to suppress.
I think his testimony was one can assume, and not sustain an objection, but he can testify if he assumes something. Well,
I appreciate that you're ruling in our favor. Thank you, Judge. I appreciate that.
I don't know that he goes that far.
Well, I think you sustain an objection.
I think the record will reflect what I did or did not do.
Let's not talk about what another person might assume, but in terms of your interview with the defendant and his admissions about being involved in electronics, did that impact how it is that you conducted some of the searches, you personally, on the devices once they were dumped or downloaded and that information was provided to you from high tech?
Mr. Harris works as a web developer for Home Depot. He would have a lot of experience in computers, computer software, websites, computer programs, and would be able to hide stuff on his computer or change it, put it in different files on his computer, easier than a layman.
Once the second set of search warrants were received from the 24th and the 27th, is that when the actual searching of the extracted data from all of these devices began by you and your team?
That's correct.
And it was only after those second series of search warrants from the 24th and 27th?
That is correct.
By that time, had the scope of the permissible searches expanded from the initial search warrants from the 18th and 19th?
That is correct.
And let's talk a little bit about that scope and what you did once you received the items back from High Tech in terms of the data that they've extracted. Can you give examples for the court of instances where, let's say for the phone, for example, or the laptop, for example, where there were things that you did not look into or did not delve into because of the scope issue that we're talking about?
If it was something simple, if it was like, it was something talking about Kroger or talking about a store or talking about a work email, to where it wasn't scheduling something or a meeting or anything like that, if we took a quick look and it was some work email, we would move on. We wouldn't delve into it. We wouldn't open it up and go further than we needed to.
Could you oftentimes do that in terms of the emails, by way of example, just by looking at the subject line?
Yes.
And did the dates and times of some of these correspondence and things, did that also impact whether or not that would be something you would look into further or disregard it in terms of the scope of your search?
That's correct. If it happened the day of course, we would look into it a little bit further than stuff that happened a week before.
Okay. And focusing in particular on the day of, were there certain items of evidence that you did find from the 18th that was of interest to you when you began the searches of both the iPhone that had been downloaded and the laptops?
That is correct.
And did some of that include contacts between the defendant and other persons?
That is correct.
Was that contrary to some of the things he had told you in his interview with you?
Yes.
When you interviewed the defendant on the 18th, did he say anything to you about whether he had been distracted that day?
He said he was not distracted.
And did he talk to you about text messaging other women outside of his marriage and inappropriate sexual relationship? Did he make any admissions about that on the 18th?
He did not.
Once you obtained these search warrants that allowed for the expanded scope into any marital issues the defendant was having, were you able to find some of that evidence within these devices?
That is correct.
And where specifically did you find most of these?
Most of these were on the iPhone, his personal iPhone.
There's been some testimony about a particular Apple computer that was recovered from defendant's home. And were you able to access that at some point and learn that that actually belonged to the defendant's wife?
We believe it belongs to, or it was mainly used by Leanna Harris.
What's the basis for that belief, having examined that in more detail after the 27th of June, 2014?
Her cell phone records, it appeared that her cell phone records had been downloaded on that computer, like on a backup. There was several files. It would say Leanna Harris as part of the file on that computer.
I want to talk a little bit about web history. And were you able to get from High Tech, once these devices were extracted or downloaded, once that data was provided to you, were you able to look at some of the web histories to make any determination about whether they may be pertinent and within the scope of the search warrant?
We did.
And can you just describe, by way of example, any web searches that clearly were outside of the scope of what you're searching for, such that you didn't do any further search of those?
SEC refs.
Okay, and just describe for the court what that is and for our record.
And for like SEC refs, any type of, Mr. Harris was a referee. He was very involved with, or appeared to be very involved with reffing high school football or football. Anytime we would see something like that, kind of move on.
I want to talk a little bit about child-free and Reddit and those types of things. Did you see any evidence that was obtained after the abstraction and after the searches began of these devices of those type of evidence involving living child-free?
Yes.
And where specifically was that found?
Those were found on Lenovo.
When you say the Lenovo, are we talking about the
T530, the one that was taken from his vehicle?
This is the Home Depot. Is that
The
correct?
Home Depot.
What about the Reddit sites?
Believe the Reddit sites were on the same computer.
Okay. All of these were found on the work computer or Home Depot computer that was encrypted.
That is correct.
You personally were involved in getting 3 additional search warrants in this case in 2015, is that correct?
That is correct.
Let's talk about those for a minute. When was the first search warrant that you obtained? Okay, great, we'll do that. We'll tender State's Exhibit 37, search warrant ending 0040, and that will be from January the 8th of 2015. I'll tender State's 38, which is a copy of that disc with a copy of the sworn testimony and your initials on it, correct, Scott?
That is correct.
I'll move on to the second one, and then this will speed things along. State's Exhibit 39, certified copy of search warrant ending 0081 from January 16th, 2015. And then State's Exhibit 40, you recognize as being the disc with your sworn testimony before Judge Taylor, I believe, correct?
Yes, sir.
Tender 39 and 40. And then the final search warrant, State's Exhibit number 41, and that is for search warrant ending 1072. These are all 15W, by the way, from 2015. And then that is from August the 28th of 2015. 42 will be the disc with your initials on it that contains your sworn testimony in support of this search warrant, State's Exhibit 41.
Correct.
Tender 41 and 42 as well.
Objection.
They're all admitted.
Let's take them in succession. The first one that was obtained on January the 8th of 2015. Describe for the court what it is, why it is that you sought and obtained this additional search warrant.
On January 8th, we had gone, well, actually, let me back up just a little bit. After Mr. Harris was arrested and placed into custody, Home Depot that day, before we could even get out there, had gone through and boxed up all his belongings. They had taken his belongings and they had photographed him, taken his belongings and put him into a stored room. We were given the photographs of his belongings, or actually all the belongings that were at the desk. I had gone through those photographs. I did not see at that time any electronic data or any electronic data storage devices. What we did is we kind of moved on. Later on in my investigation, I was going through my notes, decided that I was going to go and photograph those items just to make sure there was anything of note there. As I was photographing the items in the box at the Home Depot, I noticed that there were some flash drives in the box. Flash drives are commonly used to store information. At that time, I backed out. We went ahead and we got the search warrant for the 2 flash drives. And the first 2 flash drives were a SanDisk 256 megabyte silver flash drive and iLogic 1 gigabyte black flash drive.
And were those the subjects of search warrant ending 0040, I believe the first State's Exhibit I showed?
That is correct.
Let's talk about the one from the 16th of January 2015, the one ending 0081. Describe why that second search warrant in January of 2015.
As I was looking at the first 2, or as we recovered or seized the first 2 flash drives, we observed that there was a 3rd flash drive in the box that we had not seen that second time, or not seen when photographing. At that time, backed on again when I got a second search warrant to come back in and seize that flash drive.
Okay. And I want to talk a little bit now about the 3rd and final search warrant that you obtained in this case, search warrant ending 1072 from August 28th of 2015.
Yes, sir.
And if you will, describe for the court why it is that you obtained this 3rd search warrant, with the target being the iPhone that was recovered from the defendant when he was detained.
High Tech had a new program, or a program that they were starting to use to evaluate phones. as opposed to using like our UFED reader and what we have currently. It was called Lantern. And then we decided, since the actual phone would have to be searched again for Lantern to be used, that we would go ahead and get a separate search warrant for that.
This involved nothing new necessarily from the phone so much as law enforcement's ability to use some new system that you thought might be more advantageous to getting the data off the phone.
That's correct.
The details for these 3 search warrants, you provided this information to the magistrate court, is that correct?
That is correct.
And the basic template for it looks like, was this similar to a template that Sean Murphy, Detective Murphy, had been using? Obviously, you made some changes to it.
Yes, sir. That's the same. It was similar to his template.
Okay. But the substance of it that we have in State's Exhibit 41 and then 42, your sworn testimony, essentially the same substance, other than the addition of additional evidence that had been collected since the extraction of the devices and examining them after June the 27th of 2014.
Correct.
Just a moment, Judge. The phone that you received from Detective Thorpe, did you confirm with him that he hadn't looked on the phone or attempted to bypass the passcode or in any way prior to you speaking to the defendant?
Yeah, Detective Thorpe used to work, or actually Sergeant Thorpe, I'm sorry, used to work in same division I used to, or I do, crimes against persons. He said he'd shut the phone off and did not handle it any further.
Okay. And you did confirm that it was indeed passcode protected, meaning unless you knew the passcode, you couldn't just manually get onto the phone?
That is correct.
Okay. Thank you. I think that's all I have, Judge, this time.
Cross-examine.
All right. Is your testimony, Detective Stoddard, that you did not look onto that iPhone beyond the passcode screen until after June the 24th of 2014?
That is correct.
You obtained a search warrant for it within hours of obtaining it and chose not to look at it.
Yes, sir.
And you indicated that you did not speak to this person known as Angie K until June the 20th.
That is correct from my notes.
And do you know what time you spoke with Angie K on the 20th?
Let me see. $2,100.
Which is, for layman, 9 o'clock at night?
That would be 9 p.m. Yes, sir.
But yet, Detective Yeager, let me get his. Excuse me for one moment. On that same day, Detective Yeager had already, he provided to you hard copy reports of that information of Angie K from that iPhone 5S, specifically regarding contact information regarding Angie K, also known as Dark Phoenix, 1982. That's after he has already dumped the phone, doing the analysis, searched through it, and found that information. And you're indicating that he magically gave you that information before you spoke to her at 9 o'clock that night? Is that your understanding?
I don't understand what you're asking.
Okay. Well, I'm trying to figure out, if you didn't speak to her till 9 o'clock that night, how was it that Detective Yeager had already had a chance to look for that information, find it, and put it in a hard copy report to you that same day?
That's how it works. He would look at the phone, find the information, create a hard copy, and then give it to me. I would then investigate it and find her.
So is your testimony that he just picked this out of the blue of all the information that's on this phone, he picked out this name to give to you, that you then spoke to her at 9 o'clock?
Well, no, and once again, he was having, or Mr. Harris was having a conversation with her the day of Cooper Harris's death. So on the 18th, Angie K and Mr. Harris were talking back and forth, and pictures were exchanged, or actually he sent a picture.
This is information that you got later after searching through the phone, I take it? Or did you have it on the 20th?
On the 20th, I knew we had some, I don't have the actual, what he gave me in front of me, sir. So what I'll say is he did give me her name and some of the text. I don't know whether that text actually shows the photo that was sent or not, but that's all I received.
All right. And with regards to any other detective looking at that phone, you're not aware of any other detective who looked at that phone to give Detective Yeager that information?
No, sir.
Now, you indicated that you started speaking to Mr. Harris on scene, correct?
Yeah, it was a real brief introduction.
You got there about 4:50 and you started speaking to the arrestee, correct?
Yeah, 1650.
All right. And the fact of the matter was he was not under arrest at that point in time?
That is correct.
But you were treating him as though he were an arrestee, correct?
Oh, I did not have all the information, but yes.
Handcuffed in the back of a patrol car, not free to leave, correct?
Yes, sir.
All right. And with regards to the phone, you were made aware by Officer Piper that in fact that she had taken that phone from him without his permission from his pocket, correct?
Correct.
And at no point in time did you offer to give the phone back to him, correct?
Correct.
And at no point in time did you actually give him his personal property back, correct?
Correct.
But you allowed him to come back to you had him transported back to the headquarters in a patrol car in handcuffs and brought back to headquarters and then released from handcuffs, correct?
Yes, sir.
And you spoke with him very openly, correct?
That's correct.
He was very calm, as you indicated at that point in time, calm and collected, like you said?
Yes, sir.
All right. And at no point in time did you give him his phone back?
No.
Correct. And but you asked him at some point in time for the code to his phone, and he gave it to you willingly.
He did.
All right. You never indicated to him that, hey, don't worry, we're going to give you your phone back, correct?
No, correct.
And do you recall indicating, having a conversation with him about getting some contact information out of his phone at some point in time?
That is correct.
Okay. Was that before you asked for his code or after the code?
After, or during our conversation for it.
Okay. But it was after you asked for the code, correct?
I believe so.
Okay. And you allowed he and his wife, after you spoke with him, you allowed his wife to come into the room for them to have contact, speak with one another openly, correct?
That is correct.
Not in custody, correct?
Correct.
All right. And you did not give him his phone back at that point in time, correct?
That is correct.
Now,
And stand by. You said not in custody. He had already been advised that we were going to be taking charges out on him at that time. Because at the end of the interview, I did advise him we were going to take cruelty charges, so at that time, he was in custody. But we did allow him to speak with the wife.
he was allowed free access to have contact with his wife without being in handcuffs or secured in any way.
That is correct.
Okay. And now you're saying he was in custody at that point.
No, he was in custody. He was not free to leave, but he was allowed to see his wife.
Okay. So prior to the subsequent questioning that you had of him, you're saying he was in custody, correct?
Well, there was no subsequent.
You recall when you came back into the room later and sat down with him and questioned him? We've talked about it before.
Yes, we have definitely talked about it before, sir.
Very good. All right.
Yes.
Now, with regards to the subsequent, well, let me ask you this. The state mentioned CD. She's not a juvenile, correct?
Not at this
They
time.
referred to her as such. She's the named person in the indictment, correct? Ms.
That is
Chelsea
correct.
Doster? Okay. So there's really no need to be using initials because it's public information, correct?
Did you say
She's named in the indictment?
Michelle?
No, Chelsea
Yes.
Doster.
Yeah, Chelsea.
Thank you. And you did not actually interview her until June the 30th? Is that
No,
correct?
that is not correct.
All right. Did you interview her on June the 22nd?
That is correct.
All right. That was the phone interview you had with her?
Yes, sir.
And how long was that interview?
I don't have the CD with me, sir.
More than 5 minutes, less than 5 minutes?
I would say more than 5 minutes.
And at that point in time, did you get the information from her regarding Mr. Harris and his love for his son, Cooper Harris?
I don't recall.
Don't recall. Well, do you recall when you interviewed her on the 30th, her being very clear that she stated to you over and over that Ross absolutely loved his son?
Yes, sir.
That he had said that multiple times and made that very clear that he loved his son?
Yes,
correct?
sir.
You never told that to the magistrate, did you?
I did not.
You never told Detective Murphy that to tell to the magistrate, did you?
I don't believe so.
Did you send Detective Murphy to the magistrate with this information of there was some inappropriate sexual communications to tell the magistrate that information?
Yes, sir.
Did you advise him, make sure you don't tell him anything other than that, just leave it like it is?
No, sir.
How about this idea of researching? It's come about.
Mm-hmm.
You did not tell Detective Murphy that Mr. Harris had said he had researched these things, correct?
No, sir. I was in the interview room.
And once these search warrants started coming back, did you look at them to see what information had been provided to the magistrate to make sure it was accurate?
I did.
And did you ever correct Detective Murphy about that he in fact never stated that he researched these things?
No. On the 27th, the search warrants were redone, expanded to clarify certain points.
Right. But certainly not to clarify that point, because it stayed the same, correct?
It's research.
I'm sorry?
It's research.
It's research, so you buy into that? I'm sorry, you're saying it's research, that's what's on the warrant, correct?
I agree. Yes.
Okay, and I apologize, I'm getting too fast, so let me slow down. As far as the statement in the warrant that says that he stated that he researched these things, you admit, because you were in the interview, that is not what Mr. Harris stated, correct?
Mr. Harris did not state the word research. No.
And with regards to Detective Murphy's definition of research, are you someone who buys into that
I do.
definition of theory? I got you. Is that something that they teach you in police school, that that's what research means? Or
I think it's common sense. If I'm going to put up a ceiling fan, I watch a YouTube video how to put up a ceiling fan. I've researched how to put up a ceiling fan. I think it's that simple.
Okay. So if you watch the news tonight to see how good you look on TV, that's research for you.
It could be. If I was looking to see what questions you posed, what questions I answered, yes, it could very well be research.
But if you're just watching it because it's enjoyable to watch me or you on TV, you don't have to comment as to which.
Yes, sir.
Some people just watch things and they're not researching things, correct?
It could be, yes.
All right. In any event, when you took a warrant, some year later, excuse me, not a year later, into January, then I guess in August of this year, which would have been a year later, you have those up there.
I do have 3 search warrants up here, or actually more than 3. Which one are you looking at, sir?
I'm looking at States 41, which I believe is the last one, 1072.
That should be for the 2 flash drives?
This is for the white iPhone 5. This is the new technology search one, I'll call it.
Okay. Oh, 1072?
Yes, sir.
Yes, sir.
And in that warrant, you still have that information that you provided to the magistrate, claiming that he stated that he researched the issue of deaths in cars on the internet.
Yes, sir.
And with regards to the statement that's also in there, evidence of inappropriate such communications, you didn't provide any further information to the magistrate of the source of that information, correct?
I don't believe so.
You did not provide information to the magistrate of when that information came out.
No, sir.
You didn't provide to the magistrate any date as to when that communication occurred, correct?
No, I don't believe so.
While we're on looking at the affidavit, also the issue about the life insurance policy, that Harrison made comments to family members regarding it. You did not alter that or update it in any way, correct?
That is correct.
Did you actually listen to the phone conversation where that was mentioned?
Yes, I've seen the both of them.
All right. And you know that in fact that was not initiated by Mr. Harris, correct?
The first one was not.
And that was a very minor part of a more lengthy conversation, correct?
It was brought out, but it was a part of a 30-minute interview or a 30-minute visitation.
And you never explained that to the magistrate, correct?
No, sir.
All this information regarding phone calls made on the 18th, excuse me, or communications to whomever, you did not relate that to the magistrate, did you?
I'm sorry, please ask that again.
Sure. The communications that you testified to, you went through a long, lengthy explanation there about communications that were had on the 18th between Mr. Harris and either Angie Kay or Ms. Doster.
Okay.
That did not come up in your speaking with the magistrate, is that correct?
I don't believe so.
The new technology that you had, what was your understanding as to what that new technology was?
My understanding was there's another way to process or pull the information from the phone and to process the information.
Right. And did you think it was somehow a way to get additional information that was not available the first time it was searched?
Yes, sir.
All right. And did that turn out to be the case?
I don't know yet.
Okay. Is that because you haven't looked at that information yet?
We have not received a disk. There were some technical difficulties while doing that. We have not received a disk from High Tech yet.
Now, you took this information to this Angie Kay. Did you know her prior to June 20th, 2014?
No, sir.
And you met with her at 9 o'clock at night and spoke to her about a relationship she was having with Mr. Harris, correct?
That is correct.
Or at least communications, I guess, at least. And she said that he told her that he was unhappy, correct? Right. Now, you're certainly not vouching for her reliability, are you?
No, sir.
All right. So just because she claims that that's what he said to her, that's not necessarily disproving what he said to you. Is that correct?
No.
All right.
But it doesn't prove it either.
I understand that. Regardless, you didn't bother to tell the magistrate one way or the other, correct?
Correct.
In talking about the scope of the search, once you decided to, well, the search was already done on the phone before the 20th, before you got the second warrant, because it had already been downloaded and dumped, correct?
That is correct, sir.
When you got the second search warrant, was there a second downloading and dumping of that phone?
No, sir.
All right. So what you actually began looking at was, in fact, the initial search warrant downloading and dumping, correct?
Correct.
And when you looked at that, tell us, how did you go about doing your searching of that device?
We went about searching the device. I started with the day of, looking at what he did the day of. After that, after I started looking through that, and that included everything from emails, internet history, his calendar.
Well, let's do it one thing at a time.
Okay.
And if you have notes that have it real specific, that'd be great. If not, I
All
understand.
right, we'll start with this. We'll start with the calendar.
Okay.
Calendars, especially online calendars, have reminders, what was going on that day.
Right.
It also can add to distractions. It could say he had a meeting, he had this, he had to go to somewhere. Distractions, something that's going to make him forget Cooper in the car. It'll have a to-do list, things he needs to pick up, stuff like that.
Is that what you saw all this on his phone? Is that what you're telling us?
No, that's what we were looking for.
Okay. My question is, what did you do? When you opened the phone, you went to the calendar. We're going to start there.
Yep,
And you went where?
to the day of,
Okay, which is June 18th.
which was June 18th.
All right.
And I started my search there.
And what did you see on the calendar for June 18th?
I don't recall.
Was there anything
I
there?
had nothing of note at this time.
Nothing of note. Well, did you have personal information there?
I don't remember.
This relates to the search warrants?
It goes to the constitutional right he has to be protected and his privacy protected. If the police department is looking into his personal life and looking into all these things, have nothing to do with this case, that's exactly one of the points of our motion to suppress. Is they're improperly, unconstitutionally exceeding the scope of a warrant, because they're just looking at anything they can find, and they don't care if it's personal or not. So that's why I'm asking.
And we're going to split every year?
I don't have many left, Judge, but I'm going to do the best I can.
You don't, so don't split them.
Let me ask the next question, see if it does that,
All right,
Judge.
open the door.
I'm not sure, I'm sure what Your Honor's saying, but I'll try my best.
Try your least.
Well, I'm not allowed to do that, Judge.
I know that, but there's a point where it's reasonable and not reasonable, and I'm trying to discern where that might be.
Thank you very much.
Thank you.
Once you looked at the 18th and found nothing of note, did you continue to look into his calendar in other days?
I would look for a few days prior.
Any idea how many days prior?
Well, no. Less than a week.
All right. Once you left the calendar, where'd you go?
Text messages.
All right. And when you...
Or we'll just say, actually, we won't even just say text, we'll say messages.
Okay.
Because it comes up on the phone as chats, and it comes up, there's like two different files. There's a chats file that has the kick, well, all these what we're talking about are kind of in there, and it also has text messages, and it also has SMS messages on the phone.
So the category on the device you're looking at, or as you're looking at on your computer, it just has it labeled messages, correct?
I believe it says chats.
Chats. Okay.
Yep, there's chats and SMS messages.
All right.
And this is the file that, or not the file, but the UFED reader, the opening screen.
This is how it's presented to you in its organization, correct?
Yes, sir.
All right. And when you open that up, what does it provide to you? What do you see?
Yeah, you can see Kik, you can see text messages. I believe you can see other messages.
Basically, any message that's on that phone, you have access to immediately, correct?
Yes.
All right. And then did you just start scrolling down and read through to see what they were?
And once again, yes, we started with the day of, and then we expanded out and went out to a week or more.
How were you able to get to the day of? Is it
You
a
look-
chronological list?
You look at the date.
Okay. Is it in order by date? That's what I'm asking.
I think you got to kind of play with it a little bit. You can get it to, by date.
Okay. When you say play with it a little bit, I just want to be real clear here.
Well, what you can do is you can kind of click up top and it'll kind of organize it for you. You can start like with the day of.
Okay.
And I believe it's different for every time you open one up. Like Kick. If you open up Kick, you got to go through each, put it as chronological order.
Is Kick in its own box, or is it just in the messages box?
It's everything is shoved in this one file, and you open it up, and then you'll have Kick and text and stuff, and it actually comes up two different ways, because you open up one and it has everything shoved together, and then later on you could find it somewhere else on the phone, shoved in this nice little neat package. It's not easy to just kind of go, okay, I'm just going to look at one little piece here.
Okay. So when it's not easy to do that, you just had to start looking through multiple things, correct?
Yes, sir.
And in doing so, that gives you access to all sorts of personal information of whoever's device it is, correct?
Yes, sir.
Okay. In other words, it doesn't have it labeled as child cruelty information, homicide information, medical information, religious information.
That is correct.
You just had to start reading through his life to see what it was till you could find out something that you wanted to find, correct?
Yes, sir.
And you said you didn't limit it to the 18th. You went to several days prior on that as well?
That is correct.
All right. After the chats, what did you look at, if anything else?
We looked at chats. We looked at emails.
All right. And does that category open up similarly to the chats?
I believe so.
And did you again start perusing his personal emails, trying to see what you could find?
I did. Like I testified to before. If it was something like, Kroger having a sale today, and we would go beyond it.
But you wouldn't know that until you looked at it, correct?
Well,
Start reading it.
you can see the subject line on a lot of them. Some of them have a subject line, some of them don't. But if they had a subject line, or it was to where I could tell what it was, and then we would go to the next one.
Okay. So you did look at Kroger. What else did you not look at?
I'm using Kroger as an example, sir.
Oh,
Okay.
so that's not
If it was
accurate.
something, no, it could be accurate. I believe there were some Kroger emails on there.
Okay, all right.
If it was something not related to my search, or that I deem related to the search, I would go beyond. I would just go to the next.
And basically, you were the arbiter to decide whether it was related to your search or not.
When I'm searching, yes.
All right. And what the search warrant gave you authority, you understood to be any emails and communications he'd had.
What I understood it to be is anything leading to the evidence of cruelty to child and homicide.
And so you found an email indicating that he had been committing cruelty to children?
And we found an email that stated that from his work or from the daycare, talking about Cooper that day, or talking about that daycare that day. I'm not exactly Cooper, but talking about the daycare.
Any other categories you decided to peruse?
Phone log.
All right. And again, similar as you testified before, you got it in date form, you started with 18th.
Start with the 18th. We start from ground zero.
You just started tracking all of the phone calls, phone log information that was made to and from the phone?
Yes, sir.
And how many days did you go out from there?
I'm going to say a week. It could have been a little bit more, but we started with the day of. And as we got further on, it wasn't as getting each and every phone call. I started looking for specific numbers.
Okay. Because after you were getting each and every phone call, you were researching all of those phone numbers to see who they were?
Yes, sir.
Okay. And you decided at some point there's some of them that you wanted to look into further, and you started looking for those particular numbers?
Yes, sir.
your search warrants in these box where it says information of person to be searched, I'm sorry, in the list of property, articles, items to be searched, has specific instruments, but does not have a list of what you're supposed to be looking for, correct?
Which warrant are you looking at, sir?
I'm looking at specifically at states 41, states, I'm sorry, that's 1072.
Okay.
0081, I think you still have the other one up there with you, 0040. In other words, let's just do one at a time. 1072, I'm starting backwards.
That's good.
1072, on the search warrant, authorization is list of property items, articles, interests to be searched. It's a white iPhone 5.
Yes, sir.
There's absolutely no limitation as to what you're to be looking for in that white iPhone 5, correct?
Correct.
Similarly, in 0081, search warrant for the RIDATA, RIDATA